your vehicle?
Yes, sir.
Step back.
Am I being detained?
Yes, hands behind your back. Now.
Stand by. Copy.
It happened just after 9:30 a.m. on a clear Tuesday morning outside a roadside café off Route 17, a few miles north of Plano, Texas. The place was the kind of stop commuters used without thinking: white siding, a cracked asphalt lot, the smell of burnt coffee drifting out every time the door opened. A black Lamborghini Urus, matte graphite with Texas specialty plates, was parked near the edge of the lot. It stood out immediately, not because of reckless driving or loud behavior, but because it didn't belong to the visual routine of that place. Most cars there were pickups, sedans, work vans. The Urus looked deliberate, clean, untouched by dust. Next to it stood a black man in his early 40s. He was tall, around 6 feet, broad-shouldered but not bulky. He wore dark slacks, a fitted navy blazer over a light gray shirt, no tie. His shoes were polished. His hair was closely cropped, his beard trimmed with precision. No jewelry, no flashy accessories. The kind of appearance that suggested money without advertising it. He leaned against the driver's side door, scrolling through his phone, waiting for a takeout order. According to later cafe staff statements, he had been there less than 4 minutes. That's when Officer Daniel Mercer pulled in. Mercer was a patrol officer with the Plano Police Department, mid-30s, 7 years on the force. His body camera activated automatically when he stepped out of the cruiser. At first, nothing about his arrival seemed unusual. He didn't respond to a call, no lights, no sirens. He walked past the cafe entrance, glanced once at the Lamborghini, then slowed. The Bodycam footage would later show Mercer pausing, turning his head back, and watching the man by the vehicle for several seconds. Long enough to decide something. What that something was would become the core question of the entire case. Mercer approached and opened with a casual but firm tone. "Morning, that your vehicle?" The man looked up from his phone, calm. "Yes, sir. Mind telling me why you're standing out here?" "I'm waiting on my order," the man replied, nodding toward the cafe door. Mercer didn't acknowledge the answer. He asked for ID. The request wasn't framed as optional. The man hesitated, not confrontational, just cautious, and asked, "Am I being detained?" Mercer shifted his stance. "Right now I'm investigating, so yes." Investigating what wasn't stated. Witnesses inside the cafe later said they could hear parts of the exchange through the open door. The tone changed quickly. Mercer circled the vehicle once, ran his hand lightly along the hood, commented on the price of the car. "Nice ride," he said. "You own it outright?" The man responded evenly. "Yes." Mercer asked where he worked. Asked how he could afford it. Asked if the car was registered in his name. None of these questions were tied to a specific allegation. No traffic violation, no report of suspicious activity, no call from the cafe. When the man declined to answer further questions without knowing the reason for the stop, Mercer instructed him to place his hands behind his back. That moment shifted everything. The man complied slowly, deliberately, but asked again, "Officer, what is the cause?" Mercer didn't answer. He secured the cuffs. A cafe employee stepped outside, phone already in hand, recording. Within minutes, a small crowd had formed. Passing drivers slowed. Someone shouted that the man hadn't done anything. Mercer responded by ordering people back and calling for backup. By the time a second unit arrived, the man was seated on the curb, handcuffed, posture straight, expression controlled. He gave his name quietly when asked again, this time for booking. Mercer relayed it over the radio without comment. What no one at the scene knew, what Mercer did not check before making the arrest, was that the name he'd just transmitted belonged to a man with a state-issued judicial security clearance, one that would trigger alerts the moment it hit the system. And yet the arrest continued. The official reason listed later that morning would be vague: failure to comply during a lawful investigation. No mention of a crime, no citation, no evidence logged. By noon, the man had been released without charges. By evening, internal emails were circulating inside the department. And by the next morning, the question no one could answer cleanly was already spreading beyond Plano. Why was a man in a cafe parking lot treated like a suspect, until the system revealed who he really was? By mid-afternoon the same day, the Plano Police Department issued a short internal incident summary. It wasn't public yet, but it would later be obtained through a records request and matched against the body camera footage frame by frame. According to the report, Officer Daniel Mercer initiated a consensual encounter after observing behavior consistent with possible vehicle-related criminal activity. The language was vague by design. No specific statute was cited. No prior bulletin, no bolo, just a general assertion that the situation required clarification. The report stated that the man became uncooperative when asked for identification and refused to answer basic questions, which allegedly escalated the interaction. The use of handcuffs was described as temporary detention for officer safety. On paper, the sequence looked routine, but the video told a tighter, more uncomfortable story. Mercer never articulated a reason for the stop on camera. At no point did he reference a theft report, stolen vehicle database hit, or suspicious movement. The Lamborghini's plates were visible the entire time. They were clean, registered, valid. The VIN was never run before the arrest. Instead, the footage showed Mercer focusing repeatedly on the incongruity of the scene, his comments about the car's value, the man's attire, the location. "You don't usually see something like this here," Mercer said at one point, gesturing at the Urus. The man responded evenly, "That's not illegal." That exchange didn't appear anywhere in the written report. Inside the department, supervisors initially treated the arrest as a non-event. The man had been released without charges. No complaint had been filed yet. From an administrative standpoint, it looked like something that would resolve itself quietly. That assumption lasted less than 6 hours. At 6:42 p.m., Mercer's patrol sergeant received an automated notification from the department's internal systems. The name entered during the arrest had triggered a judicial credential flag. Not an arrest warrant, not immunity, but a notification protocol reserved for judges and certain court officers. The alert didn't accuse Mercer of wrongdoing. It simply logged the contact and escalated it for review. By 7:10 p.m., the watch commander had requested the full Bodycam file. By 8:00 p.m., the legal division was looped in. Still, the department did not publicly acknowledge anything unusual. When a local reporter called the next morning asking about a video circulating online showing a black man handcuffed beside a Lamborghini, the department issued a one-sentence response. "The matter is under review. No charges were filed. The department is committed to fair and impartial policing." What they didn't say was that the man had already been identified internally as a sitting judge with jurisdiction in multiple counties, someone who routinely ruled on suppression motions, officer conduct cases, and internal affairs appeals. What they also didn't say was that the judge had not raised his position at the scene, not once. He had not threatened, had not argued, had not asked for special treatment. The only question he repeated calmly and consistently was, "What is the legal basis for this detention?" That detail mattered more than anyone realized at the time. Because when Internal Affairs began reconstructing the timeline, they weren't just looking at what Mercer did, they were looking at what he failed to do. No articulated suspicion, no database check prior to arrest, no supervisor call before handcuffing, and most critically, no explanation that matched both the report and the video. By the end of the second day, the department had quietly reassigned Mercer to administrative duty pending review. No announcement, no press release, just a badge turned in at the end of a shift and a locked patrol car. Outside the department, speculation grew louder. Online clips cut the footage down to seconds. Context vanished. Accusations filled the gaps. But inside Internal Affairs, a different concern was forming, one that had nothing to do with the man's title and everything to do with precedent. If this stop was lawful, it had to be defensible without knowing who the man was. And if it wasn't, then the problem was much bigger than one officer in a café parking lot. 3 days after the incident, Internal Affairs completed the first full reconstruction of the encounter. Not a summary, not a narrative, a timeline built from synchronized sources. Body camera footage, café security video, radio traffic, CAD logs, and witness statements taken under oath. What emerged didn't look like a misunderstanding. It looked like a sequence of decisions that narrowed, step by step, until only one outcome remained. The café's exterior camera provided the first shift in perspective. From across the parking lot, it showed Officer Mercer arriving and walking past 2 other vehicles before stopping near the Lamborghini. Neither of those vehicles had drawn his attention. No occupants, no inspection, no questions. The man by the Urus had not moved when Mercer arrived. He hadn't paced, hadn't looked around, hadn't opened the hood or trunk. He stood in place, phone in hand, posture relaxed. The video showed Mercer pause, turn back, and then approach. That pause became important. Investigators replayed it repeatedly. It lasted just under 4 seconds. Long enough to make a choice. Inside the café, a second camera captured Mercer's reflection in the window as he began questioning the man. The audio was muffled, but the bodycam filled in the gaps. Frame by frame, Internal Affairs noted every question, every response, and every omission. Mercer asked about ownership before running the plates, asked about employment before identifying a violation, commented on the value of the vehicle twice. At no point did he articulate reasonable suspicion. When the man asked if he was being detained, Mercer answered yes, but could not later explain, in writing or during his first interview, what specific facts supported that detention. That contradiction became the first formal red flag. The second came from witnesses. 2 cafe employees and 1 customer independently stated that Mercer's tone shifted only after the man questioned the legality of the stop. None described the man as aggressive. None heard raised voices from him. One witness specifically noted that Mercer appeared irritated when the man declined to answer personal questions. Internal Affairs compared those statements to Mercer's report, which described the man as evasive and physically tense. The footage did not support that characterization. Then came the radio logs. At 9:41 a.m., Mercer radioed dispatch to request a secondary unit citing noncompliance. The phrase was generic, but the timing was precise. It came exactly 8 seconds after the man asked for the 3rd time what crime he was suspected of. That timing mattered. During Mercer's internal interview, he was asked directly why he escalated to handcuffs. His answer was carefully worded. "For officer safety," he said. "Unknown subject, high-value vehicle. Unclear ownership." Internal Affairs asked to follow up. Had the subject made any threats, any sudden movements, any attempt to leave? Mercer said no. They asked why he didn't run the plates before cuffing the man. Mercer paused. He said he intended to, but the situation developed too fast. The video showed otherwise. Nearly 2 minutes had passed between first contact and the use of cuffs. That explanation was logged as inconsistent. By the end of the week, investigators had identified a pattern, not from this incident alone, but from Mercer's prior stops. Over the previous 18 months, he had initiated 7 discretionary contacts involving luxury vehicles in low-traffic commercial areas. 5 involved black drivers. None resulted in arrests or citations. Individually, each stop had been cleared. Together, they formed a profile. This was no longer just about one morning at a cafe. It was about whether Officer Mercer's decision-making met constitutional standards when there was no call for service, no violation, and no immediate threat. And there was one more detail that shifted the entire trajectory of the case. During the arrest, when Mercer radioed the subject's name, dispatch responded with a brief pause, just long enough for the system to process the judicial flag. Mercer was still on scene when that pause occurred. He did not acknowledge it. Internal Affairs now had to ask a difficult question. Did Officer Mercer realize, before he removed the handcuffs, that he had detained someone with institutional authority? And if he did, why didn't his behavior change at all? By the time this question was raised, the case was no longer contained within the department. It had crossed into a space where intent, pattern, and accountability could no longer be separated. And for the first time, the outcome was no longer predictable. By the second week, the case had moved out of Internal Affairs' routine pipeline and into a more volatile phase. What began as a discretionary stop review was now classified internally as a conduct escalation inquiry, a designation reserved for incidents with potential civil liability and policy failure. That classification triggered a cascade. Officer Daniel Mercer was formally relieved of patrol duties. His reassignment to administrative work was no longer informal or temporary. It was documented, effective immediately, with access restrictions placed on internal systems. His union representative filed a notice of concern the same day, signaling that any further interviews would be contested. At the same time, the judge, still unnamed in public, retained outside counsel. That decision changed the tone. The attorney's first letter to the city of Plano didn't threaten a lawsuit. It requested preservation of evidence. All bodycam footage, all internal communications, training records, prior stop data, supervisor review notes. Anything related to Officer Mercer's discretionary contacts. The scope was broad by design. Inside the department, supervisors understood what that meant. This was no longer about defending an individual officer's judgment. It was about whether the department's oversight mechanisms would hold up under external scrutiny. And pressure started building from both directions. Mercer's union argued that the stop, while imperfectly articulated, fell within the gray area of proactive policing. They emphasized officer safety, unknown variables, and the legality of brief detentions. They pushed back hard against the suggestion of bias, calling the pattern analysis statistically misleading. Internal Affairs didn't argue publicly. They kept working. They conducted a second interview with Mercer, this time under recorded conditions with legal counsel present. The questions were narrower, more precise. Why did he choose that vehicle and not the others? Why did he escalate after the subject asserted his rights? Why was no supervisor contacted before handcuffing? Mercer's answers remained consistent, but consistency wasn't helping him. He repeated that the situation felt off, that the vehicle didn't fit the environment, that he relied on training and instinct. Investigators noted the language carefully. Instinct was not policy. Meanwhile, the cafe incident had reached the public in fragments. A short clip circulated online, no context, just a black man in cuffs beside a Lamborghini and an officer standing over him. The narrative took shape fast. Local outlets picked it up, then regional ones. The department's public statements remained controlled, almost sterile. But behind the scenes, command staff faced a more urgent problem. The judge's identity was about to become public. Court scheduling software had already logged a cancellation. His docket for the following Monday was cleared without explanation. Anyone who knew how to read the system could infer why. Once reporters connected the dots, the framing of the story would change overnight. Not a man, a judge. That raised a dangerous question for the city. If the officer's actions were defensible, the judge's position shouldn't matter. But if the stop failed constitutional scrutiny, then the judge's status amplified the risk, not because of privilege, but because of credibility. Judges don't need to exaggerate misconduct. Their word carries procedural weight. As this reality set in, the city's legal department began parallel preparations. Quiet ones, damage control scenarios. Settlement ranges were discussed internally, not as admissions but as contingencies. Internal affairs accelerated their timeline. They issued preliminary findings. The stop lacked clearly articulated reasonable suspicion. The detention escalated without documented threat. The written report omitted material facts visible on video. Those findings were not final, but they were enough. On Friday afternoon, Mercer was formally notified that he was the subject of a policy violation review with potential disciplinary outcomes up to termination. He was instructed not to contact witnesses, not to discuss the case publicly, not to represent the department in any capacity. For the first time since the cafe parking lot, the power balance had shifted. What had once been a unilateral stop by an armed officer was now a multi-front collision between policy and instinct, authority and accountability, discretion and consequence. And still, one critical question remained unresolved. Was this a case of poor judgment that spiraled, or evidence of a deeper failure the department could no longer afford to ignore? The answer would depend on what came next. The shift happened quietly, then all at once. On Monday morning, the Collin County judicial calendar updated without explanation. Several hearings were reassigned. A civil motions docket was postponed. No reason was listed, only a system-generated note. Administrative unavailability. By noon, legal reporters had noticed. By evening, the name was out. The man detained outside the cafe was Judge Marcus Ellison, a senior trial judge with over a decade on the bench. He was known less for public visibility and more for precision, strict on procedure, meticulous with evidentiary standards, and unafraid to suppress cases when constitutional lines were crossed. That detail reframed everything. Ellison released a brief written statement through counsel. It was measured, no accusations, no commentary on race, no mention of the officer by name. He confirmed only the facts. He had been detained without charges, handcuffed without explanation, and released without citation. He stated that he had not identified himself as a judge during the encounter and had no intention of doing so. The issue, the statement read, is not who I am, it is what was done. That sentence became the anchor. Within hours, national outlets picked up the story. The footage was replayed in full, not clipped. Legal analysts paused it, dissected it, rewound it. Former prosecutors weighed in. Civil rights attorneys noted the absence of reasonable suspicion. Retired officers criticized the escalation. But the most damaging development came from inside the department. As part of the ongoing review, Internal Affairs completed a deeper audit of Mercer's activity logs, this time focusing not on stops but on non-stops. Instances where Mercer observed situations and chose not to engage. The contrast was stark. On 3 prior occasions, Mercer had logged brief observations of white drivers with high-end vehicles in similar roadside settings. In those cases, he noted no action taken and cleared the scene without contact. Those entries had never raised concerns before. Now, placed alongside the cafe incident, they formed a narrative that was difficult to ignore. When confronted with this data during his 3rd interview, Mercer's response shifted. He no longer spoke about instinct, he spoke about context. He described the area as out of place for a vehicle like the Urus. He suggested that high-end cars were often linked to financial crimes. When asked to cite training materials that supported that inference, he could not. Investigators documented the exchange without commentary. The final blow came from an unexpected source, Mercer's own Bodycam. During a routine audit, an analyst flagged a moment that had initially been overlooked. In the seconds after dispatch processed Judge Ellison's name, Mercer could be heard muttering quietly, almost to himself, "Of course." The word was faint but clear. Internal Affairs isolated the audio, enhanced it, verified it against the raw file. That single word altered the entire interpretation of the arrest. It suggested recognition, and recognition carried implications. If Mercer realized, at any point, that the man he had detained held institutional authority and still chose not to de-escalate, not to reassess, not to call a supervisor, then the defense of ignorance collapsed. The department now faced a binary reality. Either Mercer acted without cause and doubled down after realizing his mistake, or the stop had never been about uncertainty to begin with. By the end of the week, the city's legal department was no longer discussing if there would be consequences. They were discussing how public those consequences would need to be to restore credibility. Behind closed doors, settlement figures were drafted, not as admissions of guilt but as acknowledgments of exposure. Officer Mercer remained on administrative leave. Judge Ellison returned to the bench the following Monday, presiding over suppression hearings. The symbolism wasn't lost on anyone. And as the case moved toward its final phase, one thing was clear: the incident outside the café was no longer a question of perception. It was a matter of record. By the time the city scheduled the closed-door disciplinary hearing, there was no longer any ambiguity about the stakes. This was no longer an internal matter that could be resolved quietly. The city faced a narrowing window. Either demonstrate accountability through process, or lose control of the narrative entirely once litigation began. Officer Daniel Mercer entered the hearing flanked by union counsel. Across the table sat representatives from Internal Affairs, the city's legal department, and an external compliance advisor brought in specifically to assess constitutional exposure. No press, no public statements. Just records, footage, and sworn testimony. Mercer's defense was structured, almost rehearsed. His attorney argued that the stop fell within the scope of proactive policing, that the officer acted on contextual cues, that hesitation or questioning by a subject could elevate uncertainty, that officer safety decisions must be judged from the moment, not in hindsight. The argument was familiar. Internal Affairs didn't challenge it emotionally. They dismantled it procedurally. They played the full, unedited Bodycam footage, not highlights, not clips, the entire interaction start to finish. They paused at the moment Mercer chose to approach the Lamborghini. They paused again when the subject answered calmly and directly. They paused when Mercer asked questions unrelated to any offense. They paused when the subject asked for the legal basis of the detention. And then they paused at the escalation. At no point, they noted, did Mercer articulate reasonable suspicion. At no point did he reference a specific crime. At no point did the subject behave in a way that justified restraint. Then they introduced the enhanced audio. The room went silent when the word "of course" played. Mercer was asked to explain it. He said it was frustration, a realization that the encounter would become complicated, that he felt the subject had withheld information intentionally. Internal Affairs asked a single follow-up. If you realized who he was, why didn't you reassess the detention? Mercer had no procedural answer. That was the collision point. Because departmental policy was explicit. When uncertainty exists, officers are required to de-escalate or consult a supervisor. Mercer had done neither. The union attempted to redirect, arguing that recognizing a subject's authority should not influence enforcement decisions. Internal Affairs agreed with one condition: authority shouldn't change whether the law is applied, but it absolutely affects how carefully the law must be applied. The hearing shifted from intent to outcome. Judge Ellison's legal team submitted a parallel notice to the city, intent to file a civil rights claim under unlawful detention and violation of constitutional protections. The filing wasn't aggressive. It was precise. Timelines, citations, and damages calculations were included. That notice accelerated everything. The city now faced public litigation involving a sitting judge, supported by video evidence and internal findings that were unlikely to withstand discovery without reputational damage. Settlement discussions reopened, this time with urgency. Behind closed doors, the decision was made. Officer Mercer would not return to patrol. The only remaining question was form. Termination would trigger arbitration and extend the public fight. A negotiated separation, paired with documented findings and remedial action, would close the case faster and limit exposure. By Friday afternoon, Mercer was offered a choice: resign in lieu of termination. He accepted. The department prepared a public statement, carefully worded, non-inflammatory, acknowledging policy violations without admitting malice. Judge Ellison's counsel signaled willingness to settle. But one final step remained before the case could be closed. The department needed to explain not just what happened, but why it would not happen again. And that explanation would determine whether this ended as an isolated incident or a defining moment. The resolution came without drama, no press conference, no podium, no speeches about values. Just documents, signatures, and controlled statements released within hours of each other. On Tuesday morning, the Plano Police Department confirmed that Officer Daniel Mercer was no longer employed by the department. The wording was precise: separation following a policy violation review. No mention of intent, no mention of race, just a clear administrative outcome. The internal findings were summarized and logged. The stop lacked articulated reasonable suspicion. The detention escalated without documented threat. The arrest was unsupported by policy or constitutional standards. Those findings were entered into the department's permanent record. Mercer's certification status was forwarded to the state licensing authority for review. The process would take months, but the trajectory was clear. His career in patrol policing was effectively over. Later that same day, the city of Plano announced a civil settlement with Judge Marcus Ellison. The amount was undisclosed, but sources familiar with the agreement confirmed it included financial compensation, legal fees, and a formal acknowledgement that the detention violated departmental policy. There was no admission of racial bias. None was needed. The evidence stood on its own. Judge Ellison issued a final statement shorter than the first. This matter is resolved. Accountability matters not because of who is involved, but because of what the law requires. He returned fully to the bench the following week. Inside the department, changes followed quietly but deliberately. Supervisors were retrained on discretionary stop review. Bodycam audits were expanded. Officers were instructed explicitly that instinct without articulation was not defensible policing. The café on Route 17 returned to normal. Trucks, sedans, morning coffee. No one talked about the Lamborghini anymore, but the case file remained. It showed how quickly authority can escalate when unchecked, how documentation can collapse when video exists, and how accountability, when applied consistently, doesn't need spectacle. The incident didn't become a landmark ruling or a viral trial. It became something more dangerous to ignore, a record. And that record answered the only question that mattered, not who was detained, but whether the detention could ever be justified. It couldn't. And that is why the outcome was inevitable. If you were standing there that morning, watching an officer detain someone without explanation, what would you have done? Drop your answer in the comments. Like the video if you believe accountability matters. Subscribe for more real case reconstructions like this.